Continue then now with, of course, some of the breakdown of the day's developments in the Senzo Meyiwa murder trial with attorney of the High Court and legal commentator Nthabiseng Dubazana. Nthabiseng, good evening. Good to have you with us once again tonight here on In Focus. In terms of the correct order of doing things, I ask this question again. Why did the defense want to open a special plea without bringing substantive application before the court to help the court make this decision?
I actually have no answer to that, but I tried to figure out how and why Advocate Defo came to that conclusion and decided to bring a special plea in the middle of cross-examination. Cross-examination wasn't complete, and the issues that he wanted to raise, especially when it pertains to confessions and all of that, are not issues that are before the court as yet. So he really put the cart before the horse. It was really premature. He had to wait it out a little bit, and I think the judge kind of alluded to that when he said that, don't you think you should rather wait first until the confessions have been put before the court, then you can do all these applications. And I found it very interesting that after the judgment was given on his application that he wanted to be written down or transcribed, because he intends on, his words were, we are not going to give up on this. It was very misinformed.
Speaking of not giving up on this, what is a special plea for a trial within a trial, and what grounds would you bring a special application for a trial within a trial?
So usually what happens is that there is some sort of conflict between, for example, what is said within the evidence in chief, also, and it comes out during cross-examination, and then versus the statements that were made. Usually when that happens, for example, if an accused person were to say that the statement that I have put down was as a result of being coerced or being forced to make it, or even as another state witness saying that this statement was not sworn before a commissioner of oaths, and then therefore it cannot be admitted into court, because in order for us to use statements, we have to lay basis for them to be handed over to the court as evidence. So if while we're busy trying to lay basis, and it comes out during that situation that certain procedures weren't followed when trying to establish the authenticity of the document we want to hand over as evidence, then what would happen is that we then request a trial within a trial to establish whether or not the procedure was followed for this specific statement. And what Advocate Defo was trying to get to was pertaining to statements that are not yet before the court. They're still within the docket. He has access to them, the state has access to them, but the court doesn't. So the court can't make a decision on something it doesn't know, or on what it has not been privy to as yet.
Yeah. Now, firstly, he had, of course, made the allegations that the rights of the accused, the four he's representing, were violated during their first appearance in court, made more than 2 years ago, in that they didn't know why they were there. Formal charges were not brought to them. They were not informed of their rights, and they were not told actually why they were appearing in court. Is that likely, and would it be then in the interest of the accused to halt the murder trial if that indeed had happened?
It's highly improbable. What happens in first appearances is that the accused persons will appear before the court, and then the state will call out the matter S versus so and so, and then the charge will be put by the presiding officer, him or herself, in saying, accused number 1 to 4 or 1 to 5, you're accused 1, you're charged with the crime of murder, alternatively assault, etc., etc. How do you plead? Would you rather? Then they read the section 6011B rights to them, whereby you have the right to an attorney, you have a right to speak for yourself, or you have a right to have legal representation, which you will pay out of your own pocket. And then the accused persons then have to elect which one of the three that they're going to do, and then after that, then the questions of whether or not their SAP 69s are present before the court in order for them to determine whether they can be released out on bail, etc., etc. It's highly improbable that on the first appearance they were not informed what the charges are.
Okay, then that takes us to the next part then, the other issue now being raised. Of course, this is what he raised last week. Now the issue that he is raising is that the accused are brought before court in a manner that is unconstitutional, meaning that they were profusely assaulted to the extent that they solicited a confession out of that assault. Now, what is the test of admissibility of a confession statement?
So Section 217 says that you need to make a confession as an accused person to a peace officer or an officer of the court, and then there's various case law that has dealt with this, and there's various ways in which this can be done. It can be reduced to writing, and then you sign upon it, or it can also be verbal, etc., etc. But now the issues based on the history of the country, in that certain confessions were made as a result of the police having brutally assaulted the accused persons to admit to things they never did. If it can be brought to light that the accused persons then gave a confession by virtue of either being coerced, basically when they're not in their sound and sober senses, then that confession may not be admitted in court. And I use may because there are certain things that the court would have to look at, which of course deal with the merits of each and every case. But then it may be that the confession will not be admitted in court. However, what was the first part of your question? I was going to deal with that.
The test of admissibility.
Yes. So that will basically be what the court would look at. But what did I want to say?
Oh,
there was something you mentioned.
Okay, here, maybe this will help us, because the judge says the confession statements are not before the court, and then there is this term called the state is a dominus litis. I'm sure it will be very important in this particular matter. Yes, dominus litis. What does it mean?
Yes. So the state basically controls the court. So the state is the one who's going to guide how the case goes from here onwards. So if the state has not brought anything before the court, you as the defense attorney cannot bring it before the court. Now I remember what I was going to say. I was going to say, if indeed the accused persons were assaulted prior to them giving a confession, these are things you solicit from your clients in the early stages of this matter while we're dealing with postponements and investigations, and especially during the time around bail applications. This is when the defense attorney would then raise the issues with the court and say, my instructions are that my clients were assaulted on this day prior to appearing to court in order to solicit a confession out of them. These are issues you should have raised before the trial started. You don't raise them in the middle of cross-examination. It is not procedure in that manner. Yeah. If you want to raise them, especially if it deals with confessions, then you wait for the state to actually bring forth the said evidence, where then you can decide to attack it based on that basis, on those issues.
Advocate Tifo argues that a special plea is a special plea, especially in its nature, in that it's a game changer. It can happen anytime. I mean, if, for example, he's already finished his cross-examination and this particular matter of a wrongful arrest is brought to his attention after he has finished his cross-examination, is he, in terms of process, then have a right to interrupt the other cross-examiner to say, no, let's bring a special plea here?
In his arguments, when he was arguing with the judge, or before the judge today, he was saying that in as much as it is the rights of his clients to bring forth this plea, he was then asked that, okay, if the Constitution says that things should be done in a certain way, if the Constitution says that procedure is procedure and it has to be followed, what would you say to that? And his response was, I would have to follow. Unfortunately for him, he's not following the correct procedure. There's no argument that he probably has a very strong case based on the things that he wants to argue. The problem is that it is not time yet. All he needs to do is just wait it out a little bit. And this current witness that is before the court has nothing to do with these things that he's alleging. This current witness is dealing with forensic evidence and all of that. It has nothing to do with the plea that he wants to bring before the court. So which means he just has to wait it out a little bit until it gets to the point that he needs it to be, and then bring up all the issues that he wanted to bring up today.
So if the state as the dominant elitist doesn't bring those confessions, the matter of the brutality meted out against the accused will never come to this court?
100%, because now he's already opened their eyes, so to speak, that there is going to be a dispute on that. They may make a very strong choice on not even, using that confession at all, and then just let the accused person come to the dock and give their evidence. Then what? What are you going to then argue on? Because that evidence is not before the court. Just because you have it in your possession as a result of the docket having been given to you, or copies rather of the docket being given to you, does not mean that it is going to be used by the state. Not everything in the docket is actually used as evidence before the court.
What then about the assertion that the confession of the two accused is what led to the arrest of the three?
We'll see how the state will play it out. If indeed the two accused persons, their confession led to this matter being where it is today, then the state might not have any choice but to use those confessions against the accused persons. But then it affords Advocate Defo the opportunity then to do what he was doing today, and thereby, establish credibility on all of that, use all the avenues available to him in terms of Section 217 and 218 of the Criminal Procedure Act, and make sure that he tears it to pieces, and thereby, giving the court a chance to say, nope, we're not going to admit this confession. Let the accused person come to the dock and testify if I'm okay.
Nthabiseng Dubazana, as always, appreciate your time. Thanks for coming on. Nthabiseng Dubazana, attorney of the High Court and director at the Dubazana Attorneys.